Hello and welcome to the Disability Law Show. John Scholes, your host, along with Sivan Tumarkin, James Fireman. Another busy show coming at you today. Here's the contact right away, 1-855-821-5900. Disabilityrights.ca is the website. Put a help at in front of it, help at disabilityrights.ca. You got yourself an email. Lots to get through today, guys, including the top 3 mistakes adjusters sometimes make in long-term disability claims. We'll dig into that in just a bit. And the pocket employment lawyer as well. It's employment, but it has something to do with Sivan, so we'll get to that. First, we always start with the week that was, fella. How are you?
I'm good, John.
Good.
Great to be here. And let me start off with an interesting call that I got this past week from a gentleman who's calling on behalf of his wife. She's 43 years old. She's an administrative assistant, worked in her position for over 10 years. Mm-hmm. They have 3 small kids. And about a year ago or so, she started experiencing weakness in her arms and some cognitive issues, memory type of issues. And she went to see her doctor, and she was referred to a variety of specialists. They've done a whole bunch of testing, and they continue to do testing. She ended up going on disability because she obviously wasn't able to perform her job. It appeared that the condition was getting worse. And, it got to the point where she was even slurring some words. They thought that maybe there was a stroke yeah, things like that. But again, they're not completely sure. So she was off on EI sick benefits. She didn't have short-term disability, but then she applied for long-term disability through her work group plan, and she was denied. And the reason for the denial is something that we see quite often, unfortunately, in these cases where the insurance company says, we don't have a diagnosis, we don't have a label, so therefore we can't approve you for LTD. Yep. And she was ready to give up. She wasn't even going to appeal the decision, which of course is a big no-no for us. Never appeal these denials. But her husband, who has been watching the show for a while, said, no, listen, we got to call these guys. So they got in touch with me. And so I spoke with him, and I looked at the medical records. They don't really have a lot of reports, but they have consult notes from the various specialists throughout the city. And it's clear, it's absolutely abundantly clear that she is unable to function at work at the present time. And they're trying different medications, but again, they don't know what's going on. They know something is neurologically wrong, but there's a lot of testing that is still being done. And in fact, she's scheduled to go to the U.S. To undergo some sophisticated testing in some location there. But again, what do we do with this LTD denial? The basis of which is that not that she cannot work, they're not even dealing with that in the denial, it's just that there's no diagnosis. They have ideas, hypotheses, but they don't know why she's experiencing what she's experiencing. And what I told them is very simple. That's not a reason to deny a claim. The insurance company cannot legitimately and validly and legally deny your claim on the basis that there is no diagnosis. The test is, are you totally disabled to do your own occupation, if it's one of those standard policies that we see. And in that case, it was. I actually took a look at the policy that they had. There's nothing that says in the policy that you have to have a label. It's great to have a label. A label oftentimes leads to certain treatments, but this is a case where no one is questioning that she's disabled, and in fact, no one really has no one knows what the prognosis is because they can't identify what's going on. Okay. So very, very frustrating for them, very worrisome for them because she was, bringing money into the family. Now they don't have that. We can help them. That's what I told them. That's the gist of it. We can help them. I'll be starting a claim very, very shortly. And I can tell you the insurance company will come to the table. They will be forced to come to the table and either put her on claim, pay her retroactively what she's owed from when she was denied and going forward, or we're going to resolve it for some kind of a lump sum. I mean, she and her husband are going to be there with me, and we're going to decide that together. But the point is, there is no legal reason, good legal reason, for why the insurance company has denied her claim on the basis that there is no label.
Yeah, it's not ambiguous. The Supreme Court of Canada has said very explicitly, the analysis is not about the diagnosis. It is about the symptoms, exactly. And it is about whether or not this person can function at a level that's going to allow them to be able to work. And that's what's in the policy. This isn't a mystery, and it's not something that is unclear to the insurers or that they don't understand. Now, whether the specific adjuster that made this decision understood this or not, it really doesn't matter, because either the adjuster understood it and just used it as a way of trying to get out of having to pay the benefits, in which case they're on the hook, or they didn't understand it, in which case the insurance company is hiring adjusters that are not properly trained. Either way, the insurer is going to be on the hook, and they should know that. Every adjuster who is deciding whether or not you should be approved for claims should very clearly understand that it is not about a diagnosis. And if you explicitly put that in a denial letter, if you explicitly say, we are not accepting your claim because there's not a diagnosis here, that insurance company is exposed for extra contractual damages. There's no doubt about that. And that's pressure that we can put on them to pay not just what they should be paying for the benefits, but an additional amount on top of that for the way that they've treated you and the fact that you had to be without your benefits for an extended period of time because they did not properly adjudicate the claim.
John, one of the things that I want to mention, just on what James said, what I find in many instances is that people contact us because they know what the insurance company is saying is wrong. So, for example, they'll say there's insufficient medical documents to show that you're disabled, and you know you're disabled. Your doctors have said you're disabled, so you know that the premise upon which they're now relying to deny your claim is wrong. But in a case like this, let's draw a distinction. They are telling you there is no diagnosis, therefore we're denying your claim. Unless you look at the policy and have the legal background to understand that they actually can't rely on that to deny your claim, you're going to think that they're correct because they're in fact telling you something you already know. There is no diagnosis. So it's one of those instances where this lady actually said, yeah, that's true.
Right.
I don't have one. But then she extrapolated that, though, well, they must be right then that if there is no diagnosis, I have no claim. No, you have to test what the insurance company is saying. If they're denying your claim, don't take what they say at face value. You have to look at it. At the very least, come to us. At no charge, we'll look at it and we'll tell you if you have a case.
I'm betting this comes up quite a bit with mental illness because a lot of those go undiagnosed because they don't have a diagnosis yet, like you said.
Yeah, for sure it does. But a lot of times also with cognitive issues, especially with head injuries, the medical science just hasn't advanced to the point where MRI technology is able to pick up when you have a moderate head injury what the actual mechanism is that is causing symptoms, and you see that quite frequently. I'm not going to pretend to be a doctor, but it's what you see very frequently when you review the medical file of people that are suffering from mental health issues, cognitive issues. You see that all the time.
The number 1-855-821-5900. Use it, write it down, keep it to get a hold of these guys. Remember the team. The email address is help@disabilityrights.ca. And we'll get to an email now. This one I'll send you over to you, James. Says Sierra says, my sister has MS. She's 33 and worked for 6 years as a marketing agent. She was one of the best at her company, but her illness has gotten worse. She can't continue to work and has applied for long-term disability. The insurance company told her that she didn't have enough medical evidence to support her claim. Her doctors agree that she won't be able to go back to work. She appealed her denial, but we don't think it's going to change. No kidding. Should she expect anything to happen with her appeal? Is there anything we can do?
Well, she shouldn't expect anything to happen with the appeal, that's for sure. And this is what we see all the time. People ask us this, or they ask us after they've appealed once, twice, even 3 times, and it virtually never works. And the reason for it is very simple. You have to think about who the insurance company is and what their interests are. And they're a corporation, it's not a secret. They are a corporation who has shareholders. And their duty to their shareholders is to make as much money as possible. That's fine. I don't begrudge them that. That is what they are supposed to do. But how do they go about making more money? Well, the answer is very simple. They take in more premiums, they pay out less benefits. Those are the 2 things that they can do. And on the claims side, the only way they can affect it is by cutting people off or denying claims. That's all they can do. And so they are looking for any reason to cut you off or deny your benefits. That's what the adjusters are charged with doing. And that is how they are valued as employees. Whether it's explicit or not, it is well understood. If you are adjusting claims, your job is to prevent as many claims from being paid out as possible. That's just common sense. And if they have found a reason to justify denying your claim or cutting off your claim, you better believe it's going to be real difficult to change their mind on that, because that adjuster knows, hey, I just scored one for our team. And if you're saying you're going to take one out of that column, you better give them a real good reason for doing it. And unless it's something that completely changes the picture that they have, then it's not going to go anywhere. You're just wasting your time. You need to start a legal claim. Take the decision out of the hands of the insurer. And as soon as you do that, as soon as they know that they're not in control anymore, all of a sudden they're very willing to come to the table and be reasonable. It's crazy how that happens, but it's almost instantaneous.
Pocket Employment Lawyer, you love this thing.
I love it. It's a new tool we created. It is free. It's anonymous. It's not only for people who have issues with their work, with their employer. You may have been fired and you want to know how much severance you're entitled to. You don't want to call a lawyer or email a lawyer. Well, you can just go to the Pocket Employment Lawyer. It's been used hundreds of times, literally in the last few weeks, all across Canada, but it also has a disability component. Because, John, a lot of people who have issues with their workplace also have issues with their insurance company. And of course, at our firm, we have both employment lawyers and disability lawyers. And so if you go to the Pocket Employment Lawyer, again, it's free, it's anonymous. It'll take you a few minutes to simply answer a few simple questions, and you just click the menu, the various options. And you will get a tailored response, an analysis of your case, a basic analysis that will give you a starting point. So forget about Googling this information. Forget about trying to get this on other websites. This is where you go in, you input information that is applicable to your case. You're going to get the analysis that's applicable to you for free. And if then you want to take it one step further and get more information about your case, again, for free, just give us a call, email us, or just click that button there. But you don't have to. At the very least, go to that Pocket Employment Lawyer website. John, you're going to give the website again. It is absolutely phenomenal, and it's spread like wildfire.
PocketEmploymentLawyer.ca is where you find it. Check it out, even if it's just to hang out and see what it can do. Coming up, guys, top 3 mistakes adjusters sometimes make in long-term disability claims. That is on the way. Stick around. We'll get to it after a wee break. 1-855-821-5900 and DisabilityRights.ca. Disability Law Show. Stick around.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back. This is the Disability Law Show. Reaching out is real simple. 1-855-821-5900 and disabilityrights.ca is the website as well. Coming up here, guys, right now. Top 3 mistakes adjusters sometimes make in long-term disability claims. Number 1's going to you, James. Number 1 is this. They make decisions on denial or approval on claims without reading all of the medical documentation you send them.
Yeah, and to a certain extent, this is understandable. I don't want to be too critical because adjusters do have difficult jobs, and typically they have hundreds of files, more than they could possibly know on an intimate basis. And each of those files can be thousands of pages.
Right.
The medical files are typically at least 300-400 pages on a simple file.
Wow.
And on more difficult files, it can be much, much longer. So the chances that an adjuster has read through every page of the medical file in detail is essentially nil, unless it is such a high-profile claim that they have to assign someone to actually go through it and do it. You can bet that they haven't gone through it the way that you ought to have, and certainly the way that we do.
Number 2 is this. They make decisions on the basis of the wrong consultants.
So again, this has to do with what happens when you are told by your adjuster you have to see one of our consultants. Or sometimes you don't even have to see them. Sometimes they'll simply tell you, we had one of our consultants review your file and here's their opinion. And their opinion contradicts what your treating doctor says. And people get freaked out, understandably so. Well, here's the thing. I can tell you there's a lot of lawyers in our field who don't know the difference between a physiatrist and an orthopedic surgeon and a neurologist. And there are stark differences between a lot of these different types of specialties. And these are just the MDs, the doctors. There's other types of practitioners. And my gut sense, just from dealing with these kinds of claims over the last, I don't know how many years, is that adjusters often are very confused by who it is that they should be getting to review a case or assess you. So stark example. You have chronic back pain, and they'll have you seen by a family doctor, somebody who is not a chronic pain specialist or a physiatrist. Generalist. So you have a psychiatric issue, a psychological issue, let's say. And again, they'll have your file reviewed by a non-doctor. Oftentimes when they say consultant, in many instances we find out it's somebody without a medical degree. I'm not diminishing their expertise, right? I mean, a PhD in psychology is still somebody that has expertise, but that person who, is a psychologist cannot properly assess somebody with an orthopedic issue. Mm-hmm. And so oftentimes when we look at these denials and the insurance company has relied on one of these consultants, we find out that the consultant doesn't have expertise in the area that is the subject of the disability for this individual. So very important to understand that oftentimes insurance adjusters, they make mistakes. They don't understand really the correlation between the different specialties.
A lot of times it's actually the system that they use.
Right.
I find with some of the larger insurance companies, when they're making a medical referral, there's 2 boxes at the top of the referral letter that they send. And one is for physical and one is for psychiatric. It's one or the other. And it's not like physical and then there's a bunch of choices underneath it. So you could pick neurologist, orthopedic surgeon, or what have you. It's just physical or not. And physical is almost always a family doctor. So you have something wrong with your body, they're sending you to someone who's essentially a GP, which is fine. They'll have general knowledge about a lot of things. But if you're having, if you've had a brain injury and you're having cognitive issues, you need someone with expertise in the brain, preferably a neurologist in most cases. You don't need a family doctor. They're not qualified in most cases to comment on it, but that's who they get sent to. And so it's sometimes not even the adjuster's fault. It's just the system the insurer has in place necessitates that you're getting in the hands of someone who doesn't know what they're talking about.
I just still find it bizarre that they would combat your claim based on someone who A, is not your treating physician, or B, hasn't even physically seen you. Like, how's that going to ever hold water?
Well, the not treating physician, I can't fault the insurer for that. I have to be fair about this. So, they need to be able to get their own opinions, and they're entitled to rely on that, and that's fine. I can't begrudge them that. So if they want to hire an appropriate doctor and have you assessed in a thorough assessment, fine. It's still not going to carry as much weight as a treating doctor's opinion, but it's not useless either. It has some validity to it if they do that, but it is so rare that we actually see the insurance company not only hire the right doctor, but hire the right doctor to actually do an assessment of the person in person.
We are talking the top 3 mistakes adjusters sometimes make in long-term disability claims, and the third and final is this: they've misread or misunderstood the LTD policy.
Well, that's sort of a generous way of putting it. That's assuming that it's a mistake. But let's assume that for the moment. Some of the things that we see happen frequently is, our clients will call us and they'll say, oh, well, we were told that our benefits are going to end because the 2-year mark is coming up and that's when the policy ends. And usually when you take a look at the records, the adjuster hasn't exactly said that. They've implied that. And what they're getting at is after 2 years of getting benefits, the definition of disability changes. And the test does get harder, but that doesn't mean you can't continue to receive benefits if you pass the harder test. If you can show that you cannot do any occupation that you're qualified for, then you're entitled to continued benefits until you're 65 years old. But a lot of times it will be presented as there's only 2 years and you've already gotten them. Another one that you'll see a lot of times, and this is certainly wrong, is people will be told, well, there's no objective measure of disability.
Right.
There's no objective evidence that shows that you have disability and therefore we're cutting you off. That's completely wrong. There is nothing in virtually any policy I've ever seen that says you need to show objective medical evidence. Certainly it helps if you have it.
Yep.
I'm not going to deny that. But not having it doesn't mean you are not entitled to benefits. It's certainly not in the policy. And this is something, again, the Supreme Court of Canada has made very clear. You do not require objective medical evidence. What you require is to be able to show that you legitimately suffer from the symptoms that are preventing you from being able to work. And as long as there's no issue with your credibility, as long as people aren't able to show that you're malingering, that you're doing something that obviously suggests that you're not as disabled as you are, and as long as there's no testing that suggests you're not really trying and you're doing all the rehabilitation that has been recommended, then your claim ought to be accepted, whether there's objective evidence or not.
Coming up here, how to handle a harassing insurance adjuster. That's on the way. You want to reach out in the meantime, 1-855-821-5900 and disabilityrights.ca. This is the Disability Law Show. There's more coming up. Stick around.
You were being harassed, and when you said something about it, You're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
All right, welcome back to the Disability Law Show. I'm John Scholes, Sivan Tumarkin, James Fireman answering your questions. A place to put a question if you have one anytime. We'll get it back here on the show, mydisabilityquestions.com. You can put your question in there, enter it. It will be answered by one of these two fine gentlemen or a member of the team. You can also search various questions that have already been laid down there and with comprehensive answers, so do that. Again, mydisabilityquestions.com. Fellas, this one comes from Harriet. Harriet says, I've been harassed by my LTD adjuster for the past month, and I don't know what to do. He calls me every week and tells me that he needs more information, and if I don't give it to him, he'll cut me off. I have panic attacks every time he calls. Last Friday, he sent a letter saying that my payments will stop in 3 months because I've reached the 24-month mark. I get CPP disability, and my doctor says that I still need a lot of treatment before I can go back. My husband wants me to appeal, but I just don't want to deal with the adjuster anymore. Should I just accept my cutoff and rely on the CPP?
So this is unfortunately something that happens more frequently than it should. In fact, it should never happen, but it happens quite a lot. So first of all, do not appeal, Harriet. Your husband is wrong in that. And not only should you not appeal, but you should let us into the picture, because one of the things that happen when we get into the picture, we represent someone, is we now become the front line. Like we're the ones who are communicating with the adjuster now. The adjuster is not allowed to deal with you anymore. Plus, when we start a legal claim, that adjuster is actually out of the picture. Internally within the insurance company, your claim, once we start that legal process, shifts to a different department. There is a new adjuster whose sole job it is to try and resolve the claim, and there's a lawyer there. So, in that situation, you can actually focus on getting better. You don't have to deal with this adjuster anymore. And John, one of the things that we tell people, I tell people at least, is if your adjuster is being aggressive, unnecessarily aggressive, and is bullying you, first of all, document everything in writing. Make sure that you are writing to the adjuster an email actually contemporaneously after the call and say, this is what happened, this is how I feel, this is what you've said. Make sure it's documented. Make sure you go to your doctors and tell them about this behavior of this adjuster. And by the way, incidentally, and again, I'm talking just in generalities here, you should be able to also ask the manager there, the insurance company, whoever is the higher up, for someone else, especially if this person continues to bully you and continue to harass you. Now, in Harriet's case, John, she's told now, she got a letter saying that her payments will finish in 3 months. And that's despite the fact that she's on CPP disability, which means the government has qualified her as having a severe and prolonged disability. There is no reason why the insurance company is telling her that she's going to be cut off. But the fact that they've done that now, and they've used that excuse of the 2-year mark, I'm assuming here that she's not 63 years old and the policy doesn't expire at age 65. The fact that they've done that, despite the medical opinions that she's still disabled, despite the fact that she's on CPP disability, despite all that, they've done that. There is no question in my mind that we can start a legal claim right now and we can force the insurance company to the table. Now, John, I'll tell you this. I've had situations where I've told people it's been so bad and they haven't been able to get a new adjuster. I've told them, just tell the adjuster you're only going to communicate in writing. Adjusters oftentimes hate that. They want to talk to you by phone because they get leverage over you. They know that it makes you anxious. I love nothing more than getting involved, getting on the phone with that adjuster, and afterwards getting an email from the adjuster saying, to me, I want to communicate with you in writing only. because they don't like the way, because, if they're going to be aggressive to my clients, I'll be aggressive, against them. And again, I don't want to paint all adjusters, in the same way, with the same brush. Many of them are very reasonable to deal with, especially when you're dealing once, we have a legal claim going. But it's very important to understand, Harriet, that you have a case here. You do not want to appeal it, and it's actually not going to be a difficult case to resolve. So we'd be more than happy to sit down with you, with your husband, explain all the options here. I will promise you, I guarantee you that once we get involved, you will not be speaking with that adjuster again.
The other thing on that, though, and Sivan was mentioning that we can start a claim right now. A lot of people might just think, well, I'm getting paid for the next 3 months, so I'll give you a call once my benefit starts.
Right.
Don't do that. Don't wait until the day you stop receiving your benefits. If you wait 3 months, it's going to take 3 months longer to get it resolved. And our objective is to make sure that you are not out of benefits for any longer than you need to. 1 day more is 1 day too many. So the moment that your insurance company tells you that they have made the decision to deny your claim, to cut off your benefits, you call us and we'll start the legal claim then and there. There's no reason to wait at all.
Want to slide in one more email here for the day, guys. Sanjay writes in, says, my wife has been struggling with agoraphobia and social anxiety. It's gotten to the point where she can hardly leave the house for more than a brief walk outside on a nice day. She sees her psychologist twice a week via Skype. Her insurer had her case reviewed by a consultant who's not a doctor, and they said that my wife can try to return to work. Her psychologist says it's not the right time. Does she have to follow the advice of the insurance company's consultant? What if it makes her worse? She's really scared, and the adjuster is threatening to cut off her benefits if she doesn't comply. What do we do now? What can we do?
Well, it's very simple. You listen to what your doctors are saying.
Right.
Full stop. Your doctors, your treating doctors, are the only ones who you should be listening to when it comes to making medical decisions, what treatment you should have, what medications you should be taking. If your insurance company is inserting themselves into that and is saying something that is against what your doctors are saying, that your doctors are saying either isn't necessary or worse yet, is going to be counterproductive and perhaps harm you, you absolutely should not be listening to your insurance company. Now, what's the result of that going to be? Yes, your insurance company is probably going to cut off your benefits because of that. But you want to make sure before they do that, that it is crystal clear to them that your doctor has said you are not, that you should not be doing the treatment that they are suggesting, that it will not work, will not be effective, or if it's going to harm you, that it will harm you. You want to make sure that that is in your insurance company's hands, so that when they make the decision, they cannot say they made the decision without understanding the impact of it or understanding what your treating doctor's view of that decision was going to be. So yeah, it's quite possible that they're going to cut you off, but you have to listen to your doctor. And if they make that decision, we start the claim right away, and they're going to be exposed because it is absolutely offensive for an insurance company to insert themselves into that decision-making process. Now, if you are not getting treatment, that's perfectly legitimate for an insurance company to say, well, you're not getting treated, and it's quite clear that you need some treatment, and our doctor suggests this is what it should be. I have no issue with an insurance company taking that position. That's perfectly within their rights to do. But if you are seeing an appropriate doctor or treatment provider and they have a treatment plan for you, as long as it's not a case where they've been treating you for 3 years doing the exact same thing and getting nowhere, then the insurance company shouldn't be having a view of it. In that situation, though, if it's extended treatment and it's clearly not working, I don't think it's necessarily wrong for an insurance company in that situation to say, okay, well, we should be trying something new, and if they want to suggest something, fine, then take that to your doctor and have a collaborative process where you can come up with the best treatment plan possible.
Lots of stuff on the show this week, guys. We're going to leave it there. A bunch of different ways to reach out. We covered a lot of them today. First, the phone number, 1-855-821-5900. The email address you can use is help@disabilityrights.ca, and simply disabilityrights.ca is the website you can use to find past shows. MyDisabilityQuestions.com, that website's been around for quite a while, but it is robust, and it answers a lot of questions. Go there, and of course, PocketEmploymentLawyer.ca. You love that one because there's a disability component included with all the employment stuff as well. PocketEmploymentLawyer.ca. Free of charge, anonymous. There's a contact button at the top if you want to use that as well. Till next time, Disability Law Show, thank you for joining us. We'll see you next time.